Privacy. We all know what it means, but at what level is it protected? If I'm an employer, what do I have to do to protect my employees' privacy? Work laptops, work computers, work phones. What do I do to protect their privacy? Where's the line? At home, all these houses now have cameras. What can they record? Can they record? Where can cameras be pointed? Can something be pointed in my yard? Someone who buys a drone, who flies it over my house, flies it over the community, flies it over schools, potentially airports. At what level or what protections are there for that privacy? And then the kicker, can I do something about an invasion of my privacy? Is there a legal recourse? Can I sue? Is it criminal perhaps? These questions we're looking to answer.
This episode of Off the Cuff is brought to you by Weaver Simmons, and we're very pleased to bring it to you. I hope you enjoy.
Welcome to Off the Cuff. I'm Dhiren.
I'm Matt Butler.
And before we get into today's topic, I wanted to give you guys a little heads up on a timely news article that just came out recently. And it goes to what we talked about in our last two episodes, PostScript and our YouTube show. We talked a lot about sport culture. And if we focused on, hockey and Olympics, and we talked about professional sports and amateur sports. But one of the things Will Russell, our prior guest, focused a lot on was how do we change the culture in these organizations? And he talked about the UCCMS, the code of conduct, and, the sports commissioner coming in and trying to ameliorate some of the problems. But recently, we just got an article from the National Post, and the chair of Hockey Canada testified recently to the MPs in Ottawa, and she indicated that, okay, well, there's a toxic culture and a culture of silence that unquestionably exists in Hockey Canada, but then tried to say that it also exists in many other parts of society, such as education, business, politics, and religious institutions. But she did then go on to say that it's counterproductive to say that this is a hockey problem or to scapegoat hockey as a centerpiece for toxic culture. And it's interesting because we do know now, with what has been uncovered, that Hockey Canada specifically established funds to pay off settlements for these sexual assault claims. And so I think that's where more of the outrage has started, and we're now starting to see more pushback from that. So if you haven't checked out our last episodes, go check them out. Will Russell does a fantastic job of explaining, what, he talks about exactly this. So have a listen and give us some feedback, throw some comments, because we're always excited to hear what you guys have to say. Now, that brings us to today. What we got today?
Privacy.
Oh.
We all know what it is, as you heard in my rant, but a lot of people don't know at what levels or what is there to protect one's privacy, what recourse there is to protect one's privacy, or really what can be infringed upon, what cannot. Because privacy is just a general term we use, right?
Yeah.
But what is there to protect us? Yeah, exactly.
Right, because we hear that a lot, and you'll see browsing on the internet, privacy policy. Well, great. What is that? Or when you're at work, there's privacy policies, maybe not. What is that? What does that mean? You as an employee, what does that mean for you? What are your rights as an employee?
Are you just at home? What kind of level of privacy are you allotted in your own home, in your yard, on your property?
And I think a lot of what you'll hear, that the legal term is reasonable expectation of privacy. Mm-hmm. Where do I have a reasonable expectation of privacy, and in what context, right? So if I'm sitting at home, do I have a reasonable expectation of privacy for what's going on in my home? Well, of course.
One would expect so. But if I'm at work using a work computer, is there a reasonable expectation of privacy of
in the contents that are being sent?
Exactly. So where's the line? It's very interesting.
And so we had the opportunity to chat with a really great privacy lawyer from Toronto. Her name's Molly Reynolds, and she practices at Torys, and she's been doing privacy law for a very long time. And so she was able to sit down with us, which we were very appreciative of, and go through what, as an employee and vis-a-vis your employer, what rights do you have as an employee? So I think what we'll do is we'll go right into that interview with Molly.
Yep.
Thank you for joining us, Molly.
Thanks for having me, Dhiren.
And can you give our viewers and listeners maybe just a little heads up on what it is that you do?
Sure. So I lead the privacy and cybersecurity groups at Torys. We have a broad practice on the advisory side and the litigation side of privacy matters, both for individuals and companies.
And so you just said, and I didn't know this about your practice, that you will act for individuals in privacy-related matters?
That's right. Sometimes it depends on what type of matter it is. Companies tend to have more privacy problems often than individuals, but it's by no means exclusive. If you work for a very small section of employers who are federally regulated, but in Ontario, so that's banks, airlines, railroads, or shipping companies, your employee privacy rights are under a federal statute called the Personal Information Protection and Electronic Documents Act, or PIPEDA. And if your rights are violated, you can file complaints with a federal regulator, which is the Office of the Privacy Commissioner of Canada. Now, most employees in Ontario are not in this category. And if you work for another small segment, like an arm of the Ontario government, or for a public organization like a hospital or a university, you might have some privacy rights under a provincial statute called FIPA, or the Freedom of Information Protection of Privacy Act. And that mostly protects your employee information from being disclosed to the public in a Freedom of Information request. But almost everyone else, and this is a large majority of people who work in the private sector in Ontario, whether that's for a small, medium, or large size business, are not actually under any privacy statute when it comes to their employee information. So 3 other provinces in Canada, Alberta, BC, and Quebec, do have their own private sector privacy laws, but Ontario doesn't. So what that means is that your employees' privacy rights are governed by the common law, basically principles that are set down in various court decisions and sometimes labor arbitration decisions around where the line is between what's your own information and what's the company's information.
And so let's stick with, I think it's probably easier to stick with the employee privacy rights that most of the people have. So the ones that are governed by the common law. What does, when an employee joins an organization, do they have to sign off on privacy policies, or are there mandates on these organizations to have privacy policies?
So it's a good question. I'm going to talk about employee privacy policies, which is a really key tool, although not a requirement. And then also talk a little bit about a new requirement for an electronic monitoring policy. So on the first hand, there isn't really one place that employees can look to for all of their privacy rights externally. And companies are not required to have internal employee privacy policies, but it's actually really strategic for the company as well as helpful for employees to do it. So we recommend it to our clients who are organizations, as well as really recommending it for employee rights and employee privacy rights more broadly. So an employee privacy policy should be an internal document that explains what types of information the company collects on a regular basis, who it collects it from, why, so how is it going to be used, who is it going to be shared with, and how long are you going to keep it? And some of this is going to seem really basic. So I think most people would appreciate that your employer needs your banking information, your social insurance number, your contact information in order to just sort of keep a personnel file on you, to pay you, and to submit tax slips on your behalf. But they also need sort of more detailed information like your educational background, your experience. They conduct performance reviews, and they usually keep a file with your performance review, your salary over the years, sometimes leaves that you take or health accommodations. All of that is personal information, and you have the right to know how it's going to be used. And if your employer isn't sharing that proactively in an employee privacy policy, you do have the right to ask about it. You don't always have the right to object. Sometimes it is a condition of employment, but more and more we're seeing a lot of voluntary requests for collection of information. So a lot of companies are trying to collect diversity data nowadays, for good purposes. They want to improve representation, but from an employee's perspective, that's voluntary, and you don't have to give up your sort of personal demographic information just for a diversity initiative.
And do you see that kind of objection? So you're saying there's more and more objections. Does that cause an immediate discomfort in the employee-employer relationship sometimes? Like, is that a problem that you see from an employer standpoint, saying, I've got an employee who's objecting to give me this data? Or is it one of those things where, okay, employee says no, then we move on to the next request?
Well, most times it shouldn't, and it doesn't, right? So there should be that type of relationship, whether the employer has an HR department or it's a smaller shop and you might be dealing, with the owners. There should be that type of relationship where you can ask questions and to say, why do you need this? So every time I'm at a store and they ask me for my postal code, I say, why do you need this? And the cashier doesn't really care. And they'll tell me, we don't really need it. You can have those types of conversations in the employment relationship. But the situations where this does become a little bit challenging, and frankly, the situations where the employee privacy policy is really important for both employers and employees, is when there are internal investigations or external investigations, sometimes by police or regulators. And all of a sudden, an employer is in a position where they might, for example, have to review all of an employee's inbox. And so most of that will be work-related email, for example. But, sometimes people send personal emails. You see it a lot, for example, when people are getting divorced and they might be using their work email address to send emails to their divorce lawyer. That can be really sensitive personal information. And if somebody doesn't know that there are some situations where an employer is going to come across that, either because it's relevant to something that they're investigating or just accidentally, it can cause a lot of friction. So the employee privacy policy can set out situations when they might actually get access to some of this personal information. And for employers, can also really lower the expectation that an employee might have that something that I send using my work phone or my work account is going to be confidential in all cases.
And so is that, and I don't know if you're going to get into that in the electronic monitoring piece that you want to get into, but that just brings me to a question where, and I see it all the time. I'm a family lawyer mostly, and I do litigation still on the side. But so I do have to, I'm directed by clients as I use my work email, for this, because of course my home email is at home and I don't want my ex-spouse to see that. But what privacy do you have when sending those work emails or emails on a work account that are personal in nature? Does your employer have a right to just access those carte blanche, or is that part of, again, a policy? Or what does the common law say about that?
So typical lawyer answer, right? It depends. What the courts have said consistently is that employees do have some expectation of privacy when they use, their company devices or company infrastructure for personal reasons. But the employer can reduce it. They can't eliminate it, but they can reduce it through these internal policies. So a lot of companies have IT policies that say how much personal use is allowed, or these, privacy policies that say the situations in which that private information might get scooped up in terms of an internal review or investigation. But, employers shouldn't think that they can just routinely read all of the text messages or all of the emails that employees send on company devices.
Right. Okay. So that
and just to talk a little bit.
Right. It depends on, I guess, the context. But if they would be, presumably, if there was an investigation launched by police and there was appropriate court orders and things, then of course they would have to defer to that, I would imagine.
Appropriate court orders being the key one. Employers shouldn't really be handing over private employee information from their databases or their networks just voluntarily to police. That can get you in a little bit of trouble and can get you pulled into a criminal investigation, which as an employer, you don't want to be involved with. But I'll just talk a little bit about the electronic monitoring. Sure. So unlike what we were talking about, which is, not a lot of legislation around most employee rights in Ontario, as of October 11th of this year, 2022.
That surprises me. I didn't know that. I didn't realize that private organizations really were just limited to common law remedies. I didn't actually realize that. So
I know it is surprising, especially in probably like one of the biggest employment provinces in Canada.
I know.
There'd be more regulation.
Anyway, sorry, continue. I didn't mean to interrupt, but it really does shock me that there is no legislation there.
Yeah, so as of October 11th, 2022, Ontario employers that have more than 25 employees now under the Employment Standards Act have to have an electronic monitoring policy in place. And what that is an internal policy that tells employees how the company uses electronic tools to monitor employee activities. Very broad definition. But basically, what that means is almost everything that can tell you when an employee is at work or where, if it's something other than human observation in person, could be caught by this policy. So your internal document, for example, should disclose if you have pass card readers that indicate when a certain employee is entering onto the premises, or GPS devices in delivery trucks that will track a route. Surveillance cameras on a manufacturing plant floor or in a hallway would be electronic monitoring, and also just basic computer system information. So when an employee logs on to the network, when they send an email, anything that can be tracked back to that person, you need to disclose in the policy that you do this and give a high-level explanation of why. Is it for security? Is it for quality assurance? Is it for health and safety? Now, employees don't have a right to object. You can't opt out of any of these monitoring tools. It's really just about knowledge and transparency of how your employer is tracking you. But if a company doesn't actually issue this policy, and this is October 11th of this year, then employees can make a complaint through the Ministry of Labor to an employment standards officer saying basically they haven't been given a policy that tells them how they're being monitored. So it's a little bit of a scramble right now. It's not actually going to hold companies back, but I do think it's going to make some of them think twice about maybe some of the new technology that's out there that might monitor people's screens for what software they're using. Are they being alert? How much time are they spending actually, for example, at their desk? Because you are going to have to explain it to people and, be ready to answer questions.
Well, I think that this interview is pretty timely then because it's October 3rd today. And I guess we're 8 days now away from this legislation coming into place. So I think we're going to have to cap it there. But I do, I want to encourage listeners to listen to our show next week on Off the Cuff PostScript. Molly's going to be joining us again, and we're going to go into a little bit of more information that you may want to know, being surveillance, consumer surveillance, and child protection privacy policies online. So thanks for joining us today, Molly, and we'll talk to you next week.
Thanks, Dhiren.
Up next, Dhiren's Soapbox.
Welcome to my Soapbox. Today we had the opportunity to talk with a colleague of ours, Molly Reynolds, who works at the firm Torys in Toronto. She gave us some really great information. This episode's all about privacy. It's about how you protect your privacy. It's about, what to look out for, what to do, who to talk to, what should you give when asked. All of those questions were answered by Molly. It was really incredible to talk to her. But the reason for this soapbox is to give you my thoughts on what you need to do as an employee or as an employer, somebody sitting at home, listening or watching. What does this all mean? In a summary, what I say to you is, number one, protect yourself online. First and foremost, make sure you understand what you're signing up for. And that goes in your employer context as well. When you start a new job, check out the privacy policies if there are any. We heard from Molly that there's legislation in force for different provinces for private workforces. There's also legislation in place for federal employees, for provincial employees. So make sure you know what you're subject to, where you're working, and what legislation applies there, and then start to ask questions. Molly said that there shouldn't be any shame in asking why, and why you're being asked to disclose the information. That also leads into monitoring. There's new legislation coming out in October of 2022 where there's going to be electronic monitoring requirements and policy that needs to be in place. You need to, as an employee, understand when you send a private email from your work account or a private text message on your work phone, who can look at that? Who can see it? What is the ramifications of you using that private work account for personal use? Employers, it's important for you to tell your employees what they may be subject to, and so they understand that when they're using work equipment. And ultimately, when employers are presented with appropriate court orders, as we heard from Molly, they may have to release that information, whatever it may be, for the purposes of some sort of investigation. So I urge you today, take a look at those policies. And the most important thing is read the fine print. Molly said it best. She said it. Make sure you understand the fine print. I urge you to read it and understand it. And if you don't understand it or read the fine print, you may be subject to the release of your own personal information when you otherwise either could have prevented it or didn't want it out there. And so that should be the takeaway from today. I hope you guys have enjoyed it. We'll see you back in studio.
This episode of Off the Cuff is brought to you in part by Weaver Simmons, Northern Ontario's largest full-service law firm.
Good soapbox.
Thank you.
No problem. I'd like to thank Molly Reynolds for joining us on this episode and doing an interview. And stick around for PostScript next week because she'll be on the episode and you guys dive into more stuff about cameras and on people's homes. And I think that's important.
It's pretty juicy, actually.
Yeah,
so stay tuned because
good.
That's what you're going to want to really listen into and dial into.
Yeah. During my initial rant at the top of this episode, I talked about, what legal recourse, or I asked the question, what legal recourse do, people have if their, privacy's been infringed upon or invaded? And there is a tort, which is a way that you can, we'll say, sue someone in civil court, and the tort's called intrusion upon seclusion. Now, this is a relatively new tort. It's been developed, I think, in 2012, and there's 3 elements to it. And I'll just read them out because I think they're important to go through. 1, the defendant's conduct must be intentional. Makes sense. 2, the defendant must have invaded without lawful justification the plaintiff's private affairs. That's the invasion of privacy. Makes total sense. And then 3, the most important aspect of it, is a reasonable person would regard the invasion as highly offensive, causing distress, humiliation, or anguish. So that's an important factor because courts have really relied on that factor to determine whether or not damages should be awarded to plaintiffs, because the simple fact of someone invading your privacy does not inherently mean someone is entitled to damages,
right?
Which is important. And the seminal case for that is Jones versus Siege. We'll put the link down below. And what happened in that case was someone who worked at a bank accessed someone else's banking information, I think over a span of maybe a year or just over a year, 174 times, which is crazy.
Egregious conduct.
And this was an employee of a bank access and using their role, to access this
for their personal life.
So, and I think the damages at that time were capped at either 40 or 50,000 as well. So, if your privacy has been invaded, which it can cause humiliation, anguish, you're not inherently just entitled to damages on that front alone. You really have to go through the test, and you have to establish that the reasonable person would have seen this as egregious, as opposed to just the simple fact of your privacy being infringed or invaded.
And we get into this a bit with Molly in PostScript, and she does a really good job explaining, big sticks versus small sticks. Is it worth the litigation? Is it worth going through that length of time, that lengthy litigation? And at the end of the day, your damages are capped. And so it's something that people should know.
Yep.
People that should know exists. And that's what your legal recourse is. There's another privacy tort that was recently developed I believe it was in 2016, called the public disclosure of private facts. Now, this is another tort, another privacy tort, and I'll read the elements of the tort that for you guys to know. So it's number one, the defendant must have publicized an aspect of the plaintiff's private life. The plaintiff must not have consented to the publication. A reasonable person in the same position as the plaintiff would be highly offended by the publication. Again, that goes to your, it has to have that egregious conduct, and there's an offensive nature to it. And the publication was not of legitimate concern to the public, meaning that what you've posted online or disclosed to the public sphere would not have otherwise been important to the public. You're just doing it as a reckless act, and you can be sued for that. So, again, Molly gets into that too in PostScript, and I think it's totally worth a listen in that regard. Yeah,
and there's also criminal avenues as well.
Right.
There's the criminal act of voyeurism, which we don't have the elements before us, but typically means like if you're peeking into someone's home or really infringing upon their privacy in a very sort of intimate setting.
And the specific act too of disclosing in intimate images has become a part of the criminal code too. So there is a criminal offense for that. And that, I guess, takes us to the end of today's episode. Yep. Stay tuned on our Instagram account. We do have Sudbury Wolves tickets to give away, so we'll be doing that. So that's
pretty cool. So stick around.
That's coming soon. We'll announce that very shortly, and next week when PostScript is released, we'll announce the winner of that. And thanks for joining us today. I'm Dhiren Chauhan.
I'm Matt Butler. See you next time.